Welcome to this presentation. We'll be covering part 6 of chapter 10, which is the discovery chapter, and we're going to specifically be discussing requests for physical or mental examinations that can occur as part of the discovery process. So let's begin. Well, first of all, I'm going to kind of cover the general topic of requests for examinations and then go into what those requests might actually look like. Well, first of all, I guess we need to define the term. What is a physical or mental examination? Well, it's what we think it is. It is a court-ordered examination that the person who has filed the lawsuit, it's almost always going to be the plaintiff, has to undergo in order to maintain that lawsuit. I mean, the plaintiff doesn't have to undergo it, even if the court orders it, because the court won't make him submit to it. What the court, however, may say is, if you want to continue the lawsuit, you need to submit to this examination. But if you don't want to submit to the examination, you don't have to. It's just that the lawsuit needs to be dismissed. So the person always has a choice. Obviously, that may not be a choice they would prefer to make, but it is a choice that they would have. So the way that it starts is that the other side requests it, saying, hey, Your Honor, we need a mental or physical examination of the other guy because we have a question about some of the things that he or she is alleging. And obviously this is going to a physical condition or a mental condition. It can be either one. The rule that's important for this is Federal Rule of Civil Procedure 35, and we'll look at that in a few minutes. So what are we trying to do? Or what is not what we are trying to do, what is the Rule 35 trying to do? Well, its purpose is to ascertain whether the plaintiff's allegations are actually true. The plaintiff may be saying, I'm having severe back pain. Well, if he or she is having severe back pain, then the physician hired by the other side ought to be able to substantiate that. There are some injuries that it's really not in dispute. I mean, you either break your arm or you don't break your arm. You have a 3-inch cut on your arm, or you don't have a 3-inch cut on your arm. Physical or mental examinations really aren't going to be to handle those situations. It's usually situations wherein the injury is more debatable and whether the severity of the injury is more debatable. Many times this will be a soft tissue injury or back injuries, or they can be mental health related injuries. Which might be more susceptible than other types of injuries to claims that exaggerate the symptoms. And if you break your arm, it's either broken or it's not. You can say all day your arm is broken, but if the x-rays don't show it's broken, you're not going to get a doctor to agree that it's broken. There's going to be an x-ray, there's going to be a blood test, whatever. If there's some conclusive way of demonstrating that a person has had this particular condition and has been able to substantiate the severity of the condition, that's a less common area that we're going to see mental or physical examinations. Related to that is that it's designed to motivate plaintiffs to be truthful, which is always a good thing, just like it's important for defendants to be truthful. If a plaintiff understands, and certainly his or her attorney will inform him or her of this, that if he or she exaggerates the symptoms or the condition itself, well, it's not likely to remain unchallenged. And so they are kind of told from the beginning, hey, you're going to need to go through this, so level with us from the beginning so there's nothing that has to be explained at some later point in time. And then there's always the possibility of discovering inconsistencies. A person who is claiming chronic pain, it's in many ways difficult for a doctor to substantiate the degree of pain, but there are ways. They're imperfect, but there are ways to get at that issue. And so somebody who's completely faking or exaggerating is certainly bearing a real risk of being discovered. So when do we get to do these types of reviews? Well, the condition that we're going to examine has to be in controversy in the lawsuit. If it is something that is the basis of the lawsuit, then that would be in controversy and it can be subject to the lawsuit. Examples of cases that we often see are obviously personal injury cases, such as a medical malpractice or car accident cases. We have industrial accident cases if I am hurt at work. Paternity suits, obviously, if one person says that he is a father and the other person says, I don't think he is, well, it makes sense to challenge those results. And also disability claims. This can be private insurance disability claims or Social Security disability claims. As you can see in each one of these cases, a mental or physical condition is really at the heart of what the lawsuit is about. So how do you go about requesting it? Well, you're probably going to first talk to the opposing counsel to see what his or her position is. In fact, you'll need to do that because you'll have to submit a certificate of conference before you file it. So you're going to talk with him or her. Many times it's obvious that you are entitled to this, and so there really isn't any point in the other side opposing it, but sometimes there may be some basis for opposition. It could be that they oppose the concept globally, or it could be that they oppose the scope of the investigation that you want to do. So once you've had the conversation, or even before you've had the conversation, you're going to want to look for a doctor or mental health care provider who can do the evaluation. Sometimes there are approval lists that you get through the court. Sometimes you may have favorite doctors or mental health practitioners to be involved in these cases. It's pretty common for paralegals to be involved in making these choices. Factors that you're looking for if you're able to choose your own professionals are you want people who have obviously very powerful credentials. They've been practicing this area for quite a while and have the relevant training in medical school or in a residency or someplace along those lines. You also want people who actually do this for a living, that they're not professional witnesses. You usually don't want them to get more than, say, 10 or 20% of their income from having these types of cases. So that's an important thing to also consider, because the idea is that they receive too much of their income for it, then the jury will perceive them as hired guns or something similar to that. But on the other hand, you don't want a newbie in the area of being a witness, because you want to be able to perhaps even talk to attorneys who have hired this particular expert before to see how he actually did on the stand and how did he do his evaluation, and look at previous reports. You may want to look at videotape depositions that he has done. You want somebody who the jury will respect, but also have somewhat warm feelings. If the person has all the credentials but comes across as a real jerk, that's not the best person to have in the presentation. Probably better to have someone who has fewer credentials, but who has a bit warmer personality. And so those are some things that you want to think about. You also want to consider the possibility of how likely is this person going to find what you are saying. You know, if you are on a particular side of the case and it's a controversial diagnosis, something like maybe fibromyalgia or something like that, you would be interested in knowing what the perspective of this potential doctor is. Does he or she think this is a common medical situation? Does he or she think, generally that this is a very legitimate thing, or maybe a very questionable thing, or those types of issues you may want to explore. Okay, so you find the doctor either before or after you talk with the attorney. If you have gotten the attorney's initial agreement, then you'd want to go back and say, hey, this is the doctor I'm planning on recommending to the court. What do you think about that? And getting, of course, opposing counsel's perspective about that. Then eventually you're going to file with the court, and you're going to say, we want the examination, we think it's legally appropriate, and this is who we want to do it, and these are the manner, the date, the time, the location, the test that we want to perform. Obviously, you have to send this notice to all the parties, including the person that you want to have examined, and obviously you would do it before to that person's attorney. If there are other parties in the case, you'll need to send it to them. And of course, we need to establish good cause for the examination. And basically what good cause means is that there has to be a legally accepted reason why we are entitled to do this. But, this is a pretty difficult thing that we're asking the plaintiff to undergo. Being examined by somebody other than your physician, and in fact, being examined by somebody who's on the other side, is oftentimes a very difficult thing, especially when you're discussing situations wherein mental health issues are going to be in play, or there needs to be a certain level of personal modesty that might be an issue, and so, or pain in the examination. Those factors sometimes cause the judges to require a pretty significant level of proof, a pretty significant level of good cause before they're going to be willing to order such things. Again, each case is different, and the judge has a lot of discretion in making that judgment. We've already talked about it needing to be in controversy, so let's keep on motoring. Obviously, if the court grants the motion, it will compel the person, the party, the person who needs to submit the examination. It has to be a party, by the way, to submit it. And the order has to be very specific. You have to be there at this time, at this place, and this is the scope of the examination, and this is the person who will do the examination. There can be the possibility of subsequent examinations if there's some reason why it might be necessary. The examiner, whomever that is going to produce a report, and it has to be detailed. It has to talk about what are the diagnoses, the conclusion, what are the test results. And of course, the person who was examined can get the examiner's report, and the person who filed the motion, there was a person who requested the report, can also get similar reports of examinations that the plaintiff, or in that case the party, has also requested. Let's flip on over for just a second and look at the rule. So we're going over here to Rule 35. Let's look at this just for a second so we can have a sense as to what the rule says. Okay, so we're going to, as you can see, this rule has two sections. We have the order for an examination and then the examiner's report. So what has to be in the order of examination? In general, the court where the action is pending may order a person whose mental or physical condition, including blood group, this is probably directed to paternity, is in controversy, those are the words that we're looking for, to submit to a mental or physical examination by a suitable licensed or certified examiner. The court has the same authority to order a party to produce for examination a party who is in custody or under its legal control. Notice in motion, contents of the order. The order may be made only on motion for good cause and on notice to all parties and the person to be examined, and must specify the time, place, manner, conditions, and scope of the examination, as well as the person or persons who will perform it. And now we have the examiner's report. This is what the doctor, or whatever the practitioner is who is making the report, who's done the examination, is going to provide. So we have 6 sections here. We have request of the party or person examined. The person who moved for the examination must, upon request, deliver to the requester a copy of the examiner's report, together with all like reports of earlier examinations of the same condition. The request may be made by the party against whom the examination was ordered or the person examined. Okay, the contents. The examiner's report must be in writing and must set forth in detail the findings, the diagnoses, the conclusions, and the results. The request by the moving party, after delivering the reports, in other words, to the plaintiff, to the person who's ill, we'll call the person the ill party, the party who moved for the examination, meaning the person who wasn't ill, usually the defendant, may request and is entitled to receive from the party, the ill party, all reports of all earlier or later examinations of the same condition. But those reports need not be delivered by the party with custody or control of the party examined if the party shows that it could not obtain them. Maybe they don't have the access to it. The doctor isn't willing to give them up. Waiver of privilege. By requesting and obtaining the examiner's report. So when the ill party requests the examiner's report, or deposing the examiner, the party examined waives any privilege it may have in this action or any other action involving the same controversy concerning testimony about all examinations of the same condition. Failure to deliver report. The court on motion may order on just terms that a party deliver the report on examination. If the report is not provided, the court may exclude the examiner's testimony at trial. And finally, scope. This subdivision B right here applies also the examination by the parties made by the parties' agreement unless the agreement states otherwise. This subdivision does not preclude obtaining examiner's report or deposing examiner under other rules. And of course, we're talking about depositions here. And also, we could be talking about requests for production here. Okay, so let's go back to our PowerPoint. Let's see what the or that motion might look like. So we're going to call opposing counsel, see if there's any objections. And of course, if there's no exceptions, it may be such that you don't even need to have the motion. It can be agreed upon by the parties. And it honestly, in most cases, they are agreed upon. The plaintiff's attorney recognizes that the court's going to order it, so they don't see a reason to require an opposed motion that often would just tick off the court. So if it's inevitable, might as well do it under the more friendly terms. If the parties can't agree to the doctor, the court will make a selection. But the court is going to put a lot of weight upon the fact that, the plaintiff gets to choose his doctor to testify. So it makes sense that the defendant gets to choose her doctor to testify. If there's a reason why the doctor the defendant is picking is iffy, the court may not be willing to do that. But usually it's going to be the defendant's choice. Certainly the plaintiff isn't going to be allowed to select because, after all, the plaintiff will have already selected his own doctor. And again, you always want to check local rules whenever you're dealing with these issues because there may be something in the local rules about how to go about doing this. We're going to use the same caption we've used in all the other matters. And we're going to start again with that intro, that preamble. Of course, this isn't actual discovery. This is a motion to the court. This is different than our other discovery tools because the other discovery tools, we weren't even filing with the court. We were sending them to the other side, and the actual document we were sending was requiring the other side to do something. In this case, the other side doesn't have to do anything. Many times they will respond to the motion, especially if they oppose it, but they don't have to do anything as a result of it because court hasn't ordered anything. So this is a little bit different than the other discovery tools we've talked about. And this document is directed to the court. So here, defendant is asking the court to order plaintiff to submit to a mental examination as authorized by this rule that we've already talked about. And we can see that because we have to show that the mental condition was in controversy and we have to show good cause, we're going to have to tell a story. We're going to have to share some facts here. And we can see here there is a section where we're talking about the facts that happened. This is, again, our effort to build that in controversy good cause standard. And then we have arguments. So you're not just going to present the facts, but you're also going to cite the rule, probably cite some cases to show, hey, in similar fact patterns, the courts have found good cause and have found that it's in controversy. And you can see, obviously, you wouldn't actually use reading, but these are some key words. A court may compel a physical or mental examination of a person if the physical or mental examination person is in controversy and there is good cause for the examination. Again, that's straight from the rule, but you can see there are cases that can be cited as well. Justice, that's one of the parties, is subject to this order of this court because he is a party to the lawsuit. We know that's a requirement. And Justice's physical condition is in controversy. Specifically, Justice claims as a result of the alleged negligence of defendant, he suffered and continues to suffer from severe physical pain. So I'm not sure if a mental examination is what we should be taking in this situation. That's kind of interesting. Good cause exists. So this really is a typo. I think this should be physical examination. Let's go forward and make sure I'm reading this quickly. Good cause exists to compel Justice to submit to a physical examination because it will yield information necessary for Bandit to assess Justice's alleged injuries. Further, Justice's primary care physician, both before and following the accident, Sigmund X. Adler, has since disappeared, and information and belief is residing overseas with all of his patients' records, including Justice's, in a location unknown to the parties. This is an example where they're not reachable. His records pertain to his diagnosis and treatment of Justice's alleged physical condition are therefore not reasonably obtainable. Bandit proposes that Michelangelo Harvey, MD, be permitted to conduct the investigation. He is suitably licensed and certified to conduct the examination. This is where he's located. And this is when it's going to happen, the day that it's going to happen, the location that it's going to happen. And we're talking about basically any and all diagnoses and treatments for such conditions that he has had up to and including the date of the examination. Then, of course, we have just our standard subscription. We're going to have a certificate of conference, and this is actually lifted from the local rules from the Eastern District, so you'll want to check your local rules to make sure you're doing it as you ought to. Let's just read this particular certificate of conference. I certify, of course, this is Carrie Frog who's certifying. I certify that I've complied with the meet and confer requirement in local rule, and this motion is opposed, meaning the other side doesn't like it. It doesn't want to do it. Senior V partner, counsel for plaintiff, and I conducted the personal conference required by this rule by telephone on this date. Mr. Partner says he opposes this motion because he believes the scope of the proposed examination is overly broad. The discussions have conclusively ended in an impasse, leaving an open issue for the court to resolve. Well, let's go back and look at that language. The examination extends to the causes, nature, and severity of any and all physical complaints, disorders, neuroses, and/or psychoses that Justice has had or experienced, and any and all diagnoses and treatments for which conditions that Justice has received any time from this date up to including the date of examination. So, let's see, we don't have, okay, so this is back in 2005, so we have a 4-year window. So presumably during that time, Mr. Justice probably had some head colds and some ear infections and stuff like that that have nothing to do with the car accident. I think this is a car accident case. Let's go back and see. Yes, it was a car accident case. So it does seem overly broad. So actually, I think that Mr. Partner probably has the right of it. I think that the court would probably not accept that broad of a scope. Let's look at the certificate of services. It's going to be very similar to all the other certificate of services that we've seen, except this one is an electronic mail certificate of service. And you'd expect to see this because, of course, since it's a motion, it's going to be filed with the court. Well, of course, the federal court is going to have all these aspects electronically filed. Well, if you electronically file something, at least in the Eastern District, it's going to automatically be sent out to all the parties. So here we have, I certify that a true and correct copy of the foregoing document was served via email and also electronically served on November 20th, 2015 on the CMECF system. Again, that's the electronic filing system that Eastern District uses, which will automatically serve a notice of electronic filing on the following attorney in charge for plaintiff Buford T. Justice. And you can see that it lists address, and then you'd probably have this, because there probably wouldn't be a wet signature there because it's going to be electronic. Okay, so now we've sent it. Let's say the court has approved it, maybe has revised it, but somehow has approved it and has ordered Mr. Justice to submit. Well, how are we going to go about doing that? Well, the first thing we want to do is let Mr. Justice know, if we are representing Mr. Justice, let him know as soon as possible that this is going to happen so he can prepare himself. We'll want to explain to him the purposes of the procedure, why the other side has made this request, and why the court has approved it, so he has as good an understanding as possible. He's still not going to like it, but if he understands it, he may feel a little bit more at peace about it. I'm going to also prep him for the types of questions that physicians may ask, or the things that physician is looking for, so that he will be prepared. Also, warn the client not to discuss the facts or disclose any attorney-client communications. Also, keep in mind that the person that he's meeting with is not his own physician. This person is not going to prescribe him medication or treatments. He's going to be evaluating him, but he isn't, in fact, his doctor. And so anything he says to the physician will be part of the lawsuit. But this last one is also really important. Many times when you're talking to somebody on the other side, we recommend that you clam up, that you not volunteer anything. And I don't know that you ought to volunteer anything even in this situation. But what you want to do is you want to be familiar with all of your medical history, because the doctor is going to ask you lots and lots of questions. And if you are constantly saying, I don't know, I don't remember, then the doctor, especially since you're trying to convince him that you really do have these symptoms, you really do have this condition, and if your answers are very thin and weak and not very responsive, well, it's very likely that he's going to conclude, Justice is exaggerating, he's not in that much pain, whatever. You've given him the tools to reach that conclusion. On the other hand, if Justice comes in prepared for and ready to make a persuasive argument that he in fact has this condition, he's putting a doctor in a much more difficult position to dismiss his allegations. And so it is advantageous to come in well prepared with lots of specifics, lots of data, to be prepared for that, almost presenting the same type of case that you would present to the jury. Because keep in mind, this doctor is going to be able to talk about to the jury what you said to him or her. If you have any questions, please bring them to class. I'll be delighted to answer them. Thank you for your attention, and we will now call it a day.